right to property was one of the most controversial fundamental rights guaranteed to citizens under the Constitution at the time of its commencement. It is one of the most amended provisions of the Constitution, and ultimately, right to property was omitted from the Part 3 of the Constitution by way of the 44th Constitutional Amendment in the year 1978. Before its omission, Article 19(1)(f) provided that all citizens shall have the right to acquire, hold, and dispose of property. It was subject to restrictions under Article 19(5). Article 31, which provided for certain limitation against compulsory acquisition of property and certain safeguards for property owners. Article 31 was also omitted by way of the 44th Constitutional Amendment in the year 1978. Prior to its omission, it provided that no person shall be deprived of his property without authority of law. It meant that there had to be a law passed by the state legislature or the parliament with regards to the acquisition of property. It provided that the property could be acquired only for a public purpose. Compensation had to be paid to the person deprived of his property. However, the compensation was not required to be adequate, but some amount either in cash or otherwise. Article 31 provided that once the state legislature had cleared the bill, it had to be sent to the President for his assent. And once the President gives his assent, then the law could not be questioned in the court of law on the ground that the property acquired was not for public purpose or the amount of compensation was not paid. This was required as the government of that day wanted to abolish the Zamindari system and wanted to redistribute the land to the farmers. It was one of the most important and major social and economic reform that the government wanted to implement during the time of independence. Right to property, being a fundamental right, was coming in the way of acquiring the property, and there were certain limitations which were prescribed under Article 31, which were also coming in the way in order to acquire property from the zamindars. The zamindars did not want to give up their right to property, and therefore the battle began in the year 1950 after the commencement of the Constitution. The first year of the Supreme Court saw some very landmark judgments in favor of the citizens upholding the fundamental rights. The first judgment was with regards to freedom of speech and expression and the freedom of press, where the Supreme Court came down heavily in favor of the citizens and against the government. In the judgment of Romesh Thapar and Brij Bhushan, the right of press was given the status of a fundamental right, and the provisions of the Public Safety Act were declared void, which provided for restrictions on this right to freedom of press. The said judgment gave a mighty blow to the government as it wanted to restrict the right of press. Another major blow to the government was with respect to the judgment of State of Madras versus Champakam Dorai Rajan, where the Supreme Court declared the communal order of Madras government to be unconstitutional as it provided for reservation on religious lines and held that it violated Article 29(2) of the Constitution. It provided that Part 3 of the Constitution was sacrosanct and the directive principles of state policy were subservient and subordinate to Part 3 of the Constitution. In another judgment, in the matter of Chintaman Rao, the Supreme Court declared the MP Regulation and Manufacture of BDs Act to be violative of Article 19(1)(g) of the Constitution and declared it to be unconstitutional. These judgments caused embarrassment to the government of that day. The principle that fundamental rights were sacrosanct and directive principles of state policy were subservient to the fundamental rights was coming in the way of providing for social and economic reforms with respect to Zamindari abolition and the land reforms, which was one of the most important program of the government. In 1950, the Uttar Pradesh and Bihar government came out with the Zamindar Abolition and Land Reforms Act, which were challenged before the High Court by the zamindars on the ground that it violated the right to property and were violative of fundamental rights and therefore were unconstitutional. The Allahabad High Court issued injunction orders restraining the government from taking action under the newly enacted Zamindari Abolition Act. On 12th of March 1951, the Patna High Court declared the Bihar Land Reforms Act 1950 to be unconstitutional as being violative of Article 14, as it provided for different rates of compensation for different categories of landholders. This came as a major blow to the government, as it could not fulfill its promise of abolition of zamindars and land reforms. The Prime Minister wrote a letter on 21st of March 1951 to all the chief ministers, stating that it is well known that the abolition of the zamindari system has been a principal plank in the Congress program for many years. The government is no longer an agency for the mere carrying on of routine functions. It has to lay down the social policies and give effect to them. Therefore, it has become necessary for us to consider an amendment to the Constitution so as to remove the lacuna which have apparently crept into it. The government formed a committee in order to look into the issue and amend the Constitution if required. The draft bill of the Constitution was sent to the President at that time, and the President Rajendra Prasad, in his comments, objected to the draft amendment to Part 3 of the Constitution. In his notes, he mentioned that it is an irony of fate that this part, which stands above every other part of the Constitution, is the first to be assailed. Despite objections from the President, the Prime Minister introduced the Constitution First Amendment Bill on 10th May 1951, which was cleared and came into effect on 18th June 1951. In its statement of object and reason, it provides that during the last 15 months of the working of the Constitution, certain difficulties have been brought to light by judicial decisions and pronouncements, especially in regard to the chapter on fundamental rights. It introduced new grounds on which freedom of speech and expression could be curtailed, and it was brought with retrospective effect in order to nullify the judgment of the Supreme Court in Ramesh Thapar and Brij Bhushan. It inserted Article 15 Clause 4 for providing special measures for backward communities in order to nullify the judgment of Champakam Dorai Rajan. It further restricted the right to property in order to validate the Zamindari abolition laws by inserting Article 31A and 31B, empowering the state to acquire estates without paying equitable compensation, and also providing that acquisition of properties could not be deemed void and challenged in court of law on the ground that it is inconsistent with or violates Article 14, 19 or 31. It introduced Schedule 9, where laws could be placed to make them immune to judicial challenge even if they violated fundamental rights. This is one of the most controversial and highly criticized amendment to the Constitution, which was brought very casually and passed even more casually. Shyam Prasad Mukherjee, who was one of the drafting members of the Constitution and also the unofficial leader of the opposition, during his parliamentary speech said that what you say, that particular laws which are mentioned in a schedule to the Constitution, no matter whether they infringe any provisions of the Constitution or not, are deemed to be valid. Is that the way in which the Constitution should be amended? By this amendment, you are saying that whatever legislation is passed, it is deemed to be law. Then why have your Constitution? Why have your fundamental rights at all? You passed the fundamental rights deliberately and you clothed the judiciary with certain powers not for the purpose of abusing the provisions of the Constitution, but for giving interpretations and generally acting in manner consistent with the welfare of the people. If the Supreme Court has gone wrong, come forward and say that the Supreme Court has come to such and such conclusions which are repugnant to the basic principles on which the Constitution was based. But the Supreme Court has not had the chance to consider this matter, and you come forward with this hasty proposal that any law mentioned in the schedule would be deemed valid. Not only that, you are saying in future if any law is passed with regards to these subjects, it would be deemed to be valid notwithstanding the provisions of the Constitution. Can anything be more absurd and more ridiculous? The First Amendment was quite criticized as providing for mechanism for bypassing judicial review. It set a bad precedent for easy and casual amending of the Constitution and passing of retrospective legislation. With this amendment started the great battle of the supremacy of the legislature over the Constitution as well as over the Supreme Court. It nullified 3 judgments of the Supreme Court and gave retrospective effect to the constitutional amendments. It provided for the most controversial Schedule 9, wherein 284 acts passed by the state legislature have been placed, which are out of judicial review. It provided for the most controversial Schedule 9, wherein if any act was placed, it was beyond the purview of the courts to consider its constitutionality And even if it violated the fundamental rights, the judicial review or the courts could not look into the aspect of violation of fundamental rights. This was the beginning point of the great battle between the Constitution, the legislature, and the Supreme Court. And ultimately, it was settled with the landmark judgment of Keshwanand Bharti in the year 1973. I will be dealing with these landmark judgments in other videos.